record low wage share of national income, what in this bill will help restore the great Australian dream after COVID cutback?
Well, if you want to have a greater wage share of national income, you need more people earning wages, which means you need more jobs, and you need more people working more hours. Everything in this bill is designed to grow jobs and grow the number of hours that people work. If they want to work more hours, they have more hours available. Everything in this bill is designed at job growth. Now, the alternative would be to leave the economy on autopilot and just hope for the best and leave all of these problems in the IR system. So at the moment, during the 150 hours worth of roundtables, we heard consistently that businesses weren't feeling the confidence to re-employ casuals because there was no definition that told them what a casual was. And they felt fearful of the fact that they might potentially face double payments for the 25% loading and the things that was meant to compensate for, not just going back 6 years but into the future. And that confidence was killing their ability and want to employ people. If you have a look at the award area, with respect to part-time flexibility in the retail sector, we heard, as the National Retailers Association has been saying for 10 years, that businesses are finding that they just don't offer the hours to people, even though people may want to work the hours, because of the restrictions that exist in the relevant awards. Now, all of these things are designed to grow jobs. If you grow jobs, you grow the wages. If you grow wages, you grow the wages as a share of national income.
But is there anything that grows bargaining power to make sure that workers capture their share of that benefit?
There's nothing that diminishes bargaining power. It just makes reasonable bargains somewhat simpler to do than the intolerably complicated system which Paul Keating himself described as too legalistic. And if someone jumps over the top of your negotiation as an employee or an employee represented by a union with their employer, and you all agree, and someone jumps over the top of that, finding a technical or legal way to overturn your agreement, that doesn't empower people involved in the bargaining process. It actually robs them of their power to bargain.
Given the fact that you're squeezing the opportunity for scrutiny of some EBAs because you want these things to be hurried up, would you encourage people about the virtues of collectivism? Would you encourage people to join a union?
I think the unions do a great job in representing their members by and large. There is a specific part of a specific union that hasn't done so well there, but that was dealt with in a way with legislation this morning. But they do a great job. But I don't accept the premise of the question that in any way we're diminishing the scrutiny of agreements. There's few things more highly scrutinised in Australia than agreement making in the enterprise agreement system. What we are doing is making that less technical and legalistic. So, Andrew, an example is that the requirement which presently exists includes a requirement to basically explain to your employees the relationship of every section or clause of an enterprise agreement to an award, even if all those sections are the same as your last enterprise agreement. Now, that to us seems like duplication, an overly technical and legal approach to agreement making. They're the sort of things we're trying to fix. That doesn't diminish people's bargaining power. In fact, we'd argue that whether you're represented by a union or another organisation or employees represent themselves, making it in the fairest way simpler to reach resolutions with their employers actually empowers people.